This is the judgment of the court. When the court sat this morning to hear an appeal from Mr. Justice Nicklin's order in PMC versus a local health board, 2024 EWHC 2969 brackets KB, the court indicated that it had been interested to read paragraph 87 of Ms. Nicola Greeney's KC's submissions as advocate to the court to the following effect, quote, "It is suggested that this court may wish to await the Supreme Court's decision in square brackets Abbasi versus Newcastle upon Tyne NHS Trust and others, 2023 EWCA Civ 331, close square brackets, before handing down judgment, given that the appeal concerns the nature of evidence required to justify a departure from open justice in cases which involve a square brackets Re-S 2005 1AC 593 close square brackets balancing exercise of Article 8 and Article 10 rights. The Supreme Court's decision may well be pertinent to an issue in this appeal, including what sort of evidence a child or protected party must adduce in relation to potential future risks if they are not granted an anonymity order, and whether the Court of Appeal in square brackets JXMX versus Dartford and Gravesham NHS Trust 2015 1WLR 3647 was correct that evidence as to specific risks was not required, close quote. The court said it was concerned that if it proceeded with the argument before it had the UKSC's judgment in Abbasi, it would need to reconvene or at least request written submissions, perhaps back and forth, once Abbasi was available. The court said it felt, subject to any submissions made, that it would be more satisfactory for the argument to start once it knew what the UKSC had decided in Abbasi. It suggested that such argument could take place early in the summer term, with a judgment to follow as quickly as possible after that. The court also said that it had reconsidered whether the PIBA and the official solicitor ought to be asked to make oral submissions in the light of their helpful written submissions, and that it thought, subject to the parties' contentions, that such oral submissions would assist the court. In those circumstances, the court indicated that the 1 day allowed for oral arguments today might not anyway be sufficient, and that it was thinking that 2 days would be, in the new circumstances, a more reliable estimate. Thus, the court said, subject again to what submissions were made, that it was minded to adjourn this appeal to a new 2-day fixture after Abbasi was available. The only question, of course, was whether delay was something that was of such concern that the court should take a different course. Mr. Weir, counsel for the appellants, submitted that the court should not adjourn because Abbasi was concerned with the parens patriae jurisdiction of the court, which this case was not, and he was only seeking to invoke the jurisdiction of the court to make reporting restriction orders under Section 6 of the Human Rights Act 1998 alongside Section 37 of the Senior Courts Act 1981. In reply, he said, as Ms. Warby, KC, had also submitted on behalf of the PIBA, that uncertainty had been created by Nicklin J's judgment, and that applications for anonymity in approval applications were taking place all the time, and it was no longer clear whether the Court of Appeal's decision in JXMX versus Dartford and Gravesham NHS Trust was to be followed. Mr. Weir and Ms. Warby asked specifically that if the appeal hearing were to be adjourned, the court should give a judgment explaining at least the current position, pending, of course, any decision in this case. The other parties and interveners supported the court's suggestion of a brief adjournment. In these circumstances, we have decided, for the reasons already stated, that it is most expedient in the interests of justice for the hearing of this appeal to be adjourned to a 2-day hearing before the same court, if possible, as soon as possible in the summer term. If Abbasi in the UKSC is not available by that time, the matter can be reconsidered. We say nothing at this stage about Mr. Weir's submission on the jurisdictional basis for anonymity and reporting restriction orders, save to say that we agree with the advocate to the court that the UKSC's judgments in Abbasi may have some bearing on the jurisdictional issues that we have to decide. The court will also be grateful if the PIBA and the official solicitor can be represented and in a position to make oral submissions at the adjourned hearing of this appeal. In the concluding section of his judgment, Nicklin J set out a critique at paragraphs 147 to 159 of the model order devised by the Personal Injury Bar Association and published as a court form numbered PF10 in the light of the decision in JXMX and commonly used at approval hearings. We do not express any view on the merits of that critique. We are in no position to do so at this stage. However, in the light of the information about the practical impact of that critique, which has been provided to us at the hearing today, we would suggest that for the sake of good order, it may be best for practitioners and judges to continue to use that form for the time being. As regards the current supposed uncertainty, we were referred to a note in the Civil Procedure News, issue 1 of 2025, brackets 14th of January 2025, close brackets, published by the White Book, which said the following, quote, "Given the errors noted in the draft order, square brackets PF10, close square brackets, urgent consideration of its terms and their revision by the CPRC, square bracket Civil Procedure Rules Committee, close square brackets, would seem to be justified. Practitioners should take care to note the guidance given in the judgment, square brackets, of Nicklin J, close square brackets, and approach the draft order accordingly, close quote. As we have said, it is advisable to use PF10 in the interregnum that arises until judgment is given in this appeal. It is also worth pointing out that first instance judges remain bound by the decision in JXMX until that decision is either departed from by the Court of Appeal or overruled by the UKSC. As requested by the PIBA and the Appellant's Counsel, I will ask my clerk to upload this judgment to the National Archives Find Case Law database as soon as possible.
Well, I'm extremely grateful to your Lordship for providing a judgment which will find its way into a written form very shortly, by the sounds of it. Thank you, my lord.
Honour is satisfied, Mr. Ware. Can I just say this about fixing the hearing, looking at Alam, the listing officer, to my left? This hearing will have to be fixed for the convenience of the court, and it will not be possible, I think, to take much notice of counsel's commitments. We'll do our best, of course, but it's obviously important we get this appeal on as quickly as can possibly be achieved. Thank you. And thank you all for your help, and I'm sure the submissions that you've spent so much time in the last couple of weeks preparing will be of great use to us when we come to decide the appeal.